Hey guys, it's me. I want you to pay attention to what the advocate is doing in his line of questioning to Zungu. I think those of you who listen to the channel will know that I believe Zungu is obviously lying under oath, but nevertheless, it doesn't give a prerogative or a right to an advocate to mislead Zungu to walk right into a trap of self-incrimination as a witness. That is something in our constitution that is even prohibited for criminals or the accused. Zungu in this case is not the accused. Right? Therefore, he should be told of his rights in advance and not be asked questions that could lead to him being disciplined at work. Right? Now listen to what happens here.
Ngabe kufakazi bakho ke ukuthi okanye usobala ukuthi mungena kwi-bedroom wathola umangalelo wesithathu ephethe isibhamu. Yes.
What type of a firearm was that?
Ubephethe isibhamu esinjani?
Hlobo le 9mm.
It was a 9mm.
You also mentioned that there was a .38 pistol.
Uye wakusho nokuthi kwakukhona ke ne.38 pistol. Yes.
Who was in possession of a .38 pistol?
Ubephethe le .38 pistol.
Uma ngifika uMuzwa yinikeza uGwabini.
When I got there, Muzi gave it to Gwabini.
Now bear in mind, the man is a police officer, right? And the advocate knows this, and yet is asking him this type of a question. Now listen to his next question.
Constable, I've highlighted to you the provisions of the Criminal Procedure Act, in particular Section 40 of the CPA.
Ngikubonisa ke imibandela ke ye-Criminal Procedures Act, kakhulukazi ke u-Section 40 ye-Criminal Procedures Act. Manje mazwi ke ngixwayisile ngazo.
Having had
Yes.
or have this knowledge, did you do anything?
Sorry, I've let this go on. Are you aware that a witness like him is not obliged to answer incriminating questions? It's criminal law 1.
In terms of the Constitution?
Yes.
Section 35.
That's it. He's not obliged. The policeman finds, and then if he hasn't arrested a person, if that information can be used to charge him because he has incriminated himself. Do you want to address me on
Yes,
this?
because it was raised on some occasion. I think it was Mr. Ramsey Bele was asking questions. I had to revisit Section 35 of the Constitution.
No, but I'm asking you. What's you? Your counsel now asking a question.
Yes. It deals with accused, arrested, and detained person. That is Section 35 of the Constitution, not a witness.
So a witness can incriminate himself. Hello, can you bring the toy so that we know what you are talking about? It's towards the end, eh? Witnesses,
Yes.
self-incrimination.
So did you see what the advocate is saying? The advocate is saying he revisited Section 35 after the judge had brought it to their attention that they shouldn't ask witnesses questions that may lead to witnesses being arrested. Because remember, the witnesses are not on trial. That will obviously demotivate a lot of people from going on a stand to testify. Remember that. Because this is about Senzo Meyiwa, not about what the witness did as a policeman and how he failed to arrest who at what point in time. But defense has to do this to tarnish the witness so that they can get to credibility issues. And in the process, if you have got stains on you, because they throw everything against you, whatever sticks, then they'll use it against you. So he is now saying to the judge, well, I revisited Section 35 of the Constitution. It's about the accused, meaning those people who are arrested. It's actually true, but surely you don't think that people who have been arrested have more rights than those who have not been arrested. It goes without saying. There's no way that could be constitutional. So what does the judge do? Then he goes to their own to Detroit, which basically list case laws to buttress the very point he's trying to make, to say witnesses should not be allowed to self-incriminate without being advised by counsel. Now here, this counsel revisited Section 35 of the Constitution, but did not revisit his case law to know that he's not supposed to mislead a witness to a point of self-incrimination. Listen to this.
Now go to the section of witnesses. What's the end?
I'm on it, my lord.
Okay.
It's section 203.
What does it say?
Witness excused from answering incriminating question.
Yeah.
It says, no witness in criminal proceedings shall,
Yes.
except as provided by this act or any other law, be compelled to answer any question which he would not, or on the 30th of May 1961, have been compelled to answer by reason that the answer may expose him to a criminal charge.
Yes, that's how I understand the law. So, what's your view, Mr. Malo?
And that, folks, whether we like it or not, is a difference between judges and advocates. Judges are very senior to advocates in their understanding of the law, because the advocate is just simply there to pursue the interest of their client, but the judge must see that justice has been served. Can you see that? Justice for who? For everybody who's participating in this trial. That is very, very important. Now listen to this, then we close this video.
I was still paging. I was still paging through the provisions.
Now I read it for you.
Fortunately, I do have my tutor. If I can quickly. My understanding, my lord, is that I was at liberty to ask him questions because he's the one who raised these issues. So I'm supposed to cross-examine him. So
he can self-incriminate himself. Is that what you're saying?
Not unless if he says it does not.
No, but this court has to see to it that the law is upheld.
Yes.
So I can't let a transgression which this witness is asked to walk into without warning him. Of course, I can tell him that if you want to answer that question, you're at liberty to answer it, but you must know your rights, that as a witness, you're not a compellable witness to incriminate yourself. That's what the law says.
And this is very important for us who are viewing this trial to properly understand, because I see that there's a lot of criticism how that this judge is active and intervening. Well, if you had better advocates dealing with this trial, you would have least intervention. This I'm pretty certain about. But the advocates in this trial, for me, I've checked them out. They are not from legal aid. They literally have their own, attorney shops, for the lack of a better word, right? Now, but clearly, it's pretty clear to me that there are levels in being an advocate, right? There are different levels in terms of competency. These guys are, in as far as I'm concerned, this includes Mshololo. Mshololo may be above them, but they are in the lower ebb of efficiency and productivity in terms of their ability, their cognitive abilities, their ability to assimilate knowledge, their thinking off the feet. Mshololo is quite good at some of these things. However, she still has a lot of ground to cover in terms of her own development to be amongst the best. I wish, for example, an advocate that once represented me on a different matter, an Indian woman, if she were to be introduced amongst this bunch, you will be blown away. The moment you have something to compare with, I think many people who have never litigated, and I have, they do not have an example to compare. These guys are pretty poor. Let me just be honest with you, that are representing these this is not the epitome or an example of black excellence. I've seen advocates that are at the top of their game, and these guys are certainly not. But nevertheless, that's not the point. The purpose of this video is not to necessarily over-criticize them. It's just to simply point out that they can be very mischievous, and that is why the judge from time to time has to intervene, because they can mislead a witness into self-incrimination, as they have been doing here. Mr. Zungu is not on trial. We, by listening to him, may develop a dislike of him because he's lying under oath. At least that's my assessment. However, my assessment of Mr. Zungu lying under oath does not mean he should lose his job. Nor should the judge allow questions that Mr. Zungu will be compelled and then to live here as though he was on trial when he's not, and then tomorrow he is jobless. That should not happen. That is injustice. You get the point? That is very, very important. So the judge put it very nicely that I will not allow a witness to walk into a trap. And this is, if you look at some of the videos, the hour-long videos that I did from Shololo and Ramusipile, where I was analyzing their content in terms of their cross-examinations, you will see there where I have criticized a lot of some of their questioning is completely inappropriate, because it's like I even said, making an example in Shololo's cross-examination, the type of questions that she's asking are questions like this, which is basically, if you know anything about Russia, there is in Russia they have an equivalent of the CIA, right? Which would ask you questions like this: have you stopped beating up your wife? You get the point? This does not make sense, because it is already assuming that you are guilty of beating your wife, something which you have never started doing to begin with. So a question to say, I've already informed you about Section 40. What does that Section 40 says? It's akin to what is in the Public Service Public Service Commission's guideline for public servants, which states the following in paragraph, I think it's paragraph 4.38. I stand to be corrected of the paragraph right now because I'm not in the public service anymore. But the point is this: it reads as follows: a public servant who knows about a corrupt activity, who themselves are not involved in such an activity, but does not report such an activity, is guilty of evading collective responsibility in the public service. That's basically what this section of Criminal Act, to which he was referring the police, is saying, that the police are expected by law, if they see someone dealing with drugs, selling drugs, or someone who's carrying a firearm that may not be registered, or that they may have perpetrated a crime somewhere, because you're a police officer, you ought to execute an arrest. So this is the line of questioning of this advocate regarding the witness, but the witness is not on trial, and nor is he on a disciplinary hearing. Can you see that? So that is why that line of questioning must be prevented, because it's going to get that witness fired, but it's not going to get Senzo's killers sent to jail. Okay guys, let me quit over here. Let me quit on this particular issue. I'll give you an update of this trial and my analysis at a later stage. Ciao, ciao.